Hi everybody and welcome back. Today we're going to be talking about jury selection and specifically jury selection as it relates to litigation consulting also. Now this is obviously a topic that I am very passionate about and care about because I actually work as a litigation consultant when I'm not at Flagler helping attorneys with things like jury selection and case prep. So what happens in voir dire or jury selection, right? Voir dire literally means to tell the truth. And it's the part of the trial at the beginning where both attorneys kind of help root out any bias, allegedly, that is there in the jury pool. Lawyers from opposing sides proceed to exercise challenges against the inclusion of certain jurors until a petite jury composed of persons satisfactory to both sides is formed. One of the kind of misnomers about the voir dire process or jury selection is actually that you are selecting a jury, because the reality is you're actually excluding jurors rather than selecting them. And there are two main types of challenges you can issue. You can issue a cause challenge or a challenge for cause, and that's a challenge that you issue because the juror has some sort of relationship with the case in some capacity, right? So it could be that the juror is a dentist for the defendant, or the defendant's barber, or something like that. And so you say, this person can't really be unbiased because they somehow might, even if it's tangential, they might somehow know the parties involved. They could know the lawyers, they could know the judge, they could know any number of people. And then there are preemptory challenges. And preemptory challenges are things like, I just don't like that person, so I want them excluded. It could be that they're looking at you funny, or they don't believe you, or if it is found out over the course of conversation that there are certain things that you might not like. Like, for example, if there is a police officer on trial and someone is very pro-police in the jury selection, you might exclude that person because you might think that they might be a little biased. And then there's other types of exclusions, like Batson challenges and other things that we'll talk about later. With jury selection, right, most jurisdictions use a number of sources for the names of potential jurors, right? The lists are sorted and duplicates are usually discarded, and the jury pool is then selected on a random basis. The term that the jury serves also vary from jurisdiction to jurisdiction. So we've got this pool of usually 200 to 1,000 citizens drawn each month from these different source lists. Could be driver's license, voter's registration, the phone book, any number of things. From that 200 to 1,000, there's a panel of potential jurors that's randomly selected for each trial. The size of the panel may be increased depending on the possible difficulty of selecting a qualified jury. So, for example, in Bill Cosby's trial, they had a much bigger panel than 30. But for your normal run-of-the-mill trial, you might have 30 jurors. So then voir dire happens, right? Voir dire is the process of eliminating these potential jurors from the panel. Both prosecution and defense can object to jurors and challenge them preemptorily or for cause. So typically, if it's a 12-person jury, you might select 14. In the case of Florida actually only has 6 jurors, except for capital cases, and so typically we'll select 8 in Florida, right? Who are not selected for service are typically returned to the pool for possible use on another jury, or sometimes sent home. What are the goals of this jury selection process or deselection process? Well, there's actually a lot of different goals depending on who it is that the perspective you're taking, right? Because depending on the perspective, right, you have different purposes for being there for the trial to begin with. So the attorney's goals for voir dire are to identify and eliminate prospective jurors unfavorable to one side and then select those that will look favorable on their arguments, right? So when I help attorneys pick a jury, I'm not helping them root out bias. I'm not helping them find who's going to be the most fair. I'm trying to help them say who is going to believe us the most, right? And that's what all attorneys try and do. Voir dire is also the first time you can kind of indoctrinate prospective jurors or have some sort of influence on the kind of information they're going to hear and get them to already start kind of thinking through what might be happening in this trial. You're not allowed to present evidence during voir dire, but you could say stuff like, for example, I've worked for like a big car company before, And so we might say, who here drives a blank, right? Like, for example, just for sake of argument, like who drives a Honda, right? Oh, okay. Well, do you like your Honda? What kind of reputation do you think Honda has to you? And so we can get them to start saying all these good things about Honda, and then if I'm representing Honda, it ends up working out really, really well, right? Because I can say, remember how you guys all said all these positive things about Honda? Well, they're actually, someone's suing them saying that all of you are wrong, that's not what they say. But I can't say that second part until the actual trial. And obviously, another goal is to create a positive impression about the attorney and the client. This is where the attorney is really one of the only times the attorney has an opportunity to really have a conversation with the jury. And so the attorney wants to come across in a positive manner and be liked pretty well by the jury. Those goals, you'll notice, are completely different from the legal system's goals. The legal system is trying to determine whether a prospective juror meets the statutory requirements for jury service. There are certain things that exclude you from being on a jury, and if you don't meet those, you can't serve. The legal system also wants to discover any challenges for cause. They want to make sure that the jury is actually a quote-unquote impartial jury. It's not that the defendant's family is all going to be serving on the jury or all their best friends. It also it hopes to discover information that can lead to the intelligent exercise of preemptory challenges. Now, it's ironic how often preemptory challenges are used unintelligently, but hopefully it can help root out some sort of biases that preemptory challenges can be used for. So it's overall, though, the goal is to ensure an impartial jury is selected, whereas for an attorney, overall, the goal is not that. So happens during voir dire, right? Jurors can be asked all sorts of questions. They can be asked about their qualifications, their experience with the legal system, their relationship to the case players, attitudes about the case, about the defendant, about certain issues that are going to be relevant about the case. And questions could be very broad or very, very narrow, and there could be a lot of them or a few of them. I helped select a jury actually this past spring, and it was judge-run voir dire, and the total jury selection lasted 10 minutes. I've been part of jury selections that have lasted 2 or 3 days. And so it just depends on the case and the type of case. That depends on what kind of questions are asked. During judge-conducted voir dire, it's also very, very brief, and you don't get a whole lot of information. It's let's find the first 6 people or 12 people we could possibly find that will fit, and then let's just get going. I don't want to spend a lot of time. Judges typically say, I don't want to spend a lot of time picking a jury. So how do lawyers handle these challenges? What are the ways lawyers go about doing this? Well, before, it used to be, until the 1880s, that challenges were used to systematically or intentionally exclude certain cognizable groups from jury panels. Stroud v. West Virginia actually forbade that from happening, though. Stuff what happened was like, we don't want women. We don't want black people. We don't want gay people. We only want wealthy white men on our juries. Well, in 1880, the Supreme Court wasn't buying it and said, no, thank you. You can't exclude a cognizable group. What ended up happening, though, is, that was a law in theory. In practice, they just came up with other reasons to do that. So, in 1986, Batson v. Kentucky was argued that defined members of racial or ethnic groups as cognizable groups and said you cannot intentionally exclude racial or ethnic groups from juries. If it's found that an attorney is doing that, the other side would issue what's called a Batson challenge, and then that person might not be allowed to be excluded. The problem is, if you can come up with some race-neutral reason why someone was excluded, the Batson challenge usually will be overruled. So, typically, lawyers exercise challenges by drawing a panel from a broad cross-section of the community, which is important for 2 reasons, right? First of all, heterogeneous jurors are better decision makers, right? You don't want all of the same type of person talking about something because you might not get different perspectives. So this heterogeneity is important. There's also this appearance of legitimacy, right? We see all the time, and in fact, Dave Chappelle on The Chappelle Show even had a joking little skit about if white-collar criminals were treated like black defendants. And the perception for a lot of people is that you're never getting a jury of your actual peers. It's always people that look and act and behave completely different from you that end up sitting on your jury. To have this broad cross section in the panel is good because at least it says, look, there were, a mixed bag of races, a mixed bag of genders, a mixed bag of ethnicities that could have potentially been sat on that jury. So it at least gives this appearance of legitimacy. Lawyers also tend to use these kind of implicit personality theories to predict which jurors will favor their side on the basis of age, gender, occupation, religion, and all sorts of other things, right? And it's actually funny when you talk to attorneys about how they select juries because they all have their theories. I was talking to an attorney one time in Pensacola who said I-10 was the barrier. If he wanted all the good conservative country folks, he would only select jurors north of I-10. If he wanted the super liberal people that were going to be, bleeding hearts, that were going to be sympathetic to his case, he wanted people south of I-10. And that's just how it worked. Of course, are there conservatives south of I-10? Of course there are. Are there liberals, bleeding heart liberals north of I-10? Of course there are. But that's what he used as his benchmark for how to select a jury. Again, not a very effective method, though. They also do certain things like the similarity leniency hypothesis. This basically says that jurors who are demographically similar to the defendant will be more sympathetic to the defendants, right? So let's say that there is a young black man on trial for a robbery. I want a jury full of young black men because the idea is that they will all say, that could be me, I know what he's going through, I know what his life is like, I would have done the same thing, not guilty. Or they have the opposite effect, this black sheep effect, where jurors who are demographically similar to the defendant will be less sympathetic. Again, young black male on trial, you pick a jury of young black people and say, why aren't any of you guys in jail? None of you guys did this, right? This guy's a black sheep. He's not like the rest of you. And so you need to punish him because he's not like the rest of you, right? Lawyers also, will do things like play hunches about which jurors will be selected as foreperson and who will dominate discussions and stuff. If someone's particularly boisterous in jury selection, they'll say, oh, well, we know that person's going to be the foreman, so we need to argue the case to that person because they're going to be the foreman. And then it might be that once they get behind closed doors and stuff, when you're asking them questions about themselves, they actually clam up quite a bit. Lawyers are also really, really good at asking questions that are really completely irrelevant to what they're looking for, right? They're not diagnostic of the characteristics they're looking for at all, right? We've heard the psychological principle of confirmation bias before, which is the tendency to search for information that confirms your pre-existing beliefs or hypotheses, right? And so they'll say stuff like, attorneys will say stuff and make these broad generalizations like, women are more sensitive than men, which probabilistically may be true, right? But it doesn't mean that the 3 women sitting in front of you right now are more sensitive than the 3 men sitting in front of you right now, right? If you had Ronda Rousey on your jury, right, is she viewed as someone who's pretty sensitive? Probably not, right? She gets kicked in the face for a living. Whereas someone like me, I have this kind of aversion to pain or, being outside or dirty, and so I'm probably significantly more sensitive than Ronda Rousey is, right? And so if you were looking for a sensitive juror, it'd be a mistake to just look at our genders, right? Lawyers will ask questions like trying to compare the difference between introversion and extroversion because they think that these are somehow predictive of verdict or at least how the deliberations are going to go, which is also not really true. But they'll ask questions like, what do you dislike about loud parties? Well, I imagine if I were to ask all of you as a discussion board question, what do you dislike about loud parties? I bet every single one of you could come up with an answer, right? What would you do to liven up a party? Even the most introverted person in the world could come up with something to liven up a party, right? Would you rather read a book or attend a party? Well, that depends, right? That's a really tough thing to say. Because some people, even terribly introverted people, if I were to say, would you rather read your textbook or go to a small party with 2 or 3 of your closest friends, you're going to pick the party with 2 or 3 of your closest friends, probably, right? Because none of you read textbooks. Also, attitudes about law enforcement is another common one. What do you dislike about police officers? There's no real, everyone's going to say something negative about that question, right? No one's going to say nothing. I think all police officers are perfect. The way the question is asked makes you seem like you have to say something negative. Do you trust police officers? Yes or no? Well, yeah, I trust them if someone's shooting at me. Or no, I don't trust them that I rolled through that stop sign. How necessary are police officers? Most people say they're pretty darn necessary, right? And so it's not actually diagnostic about anything about whether or not they're going to believe the police officer more or view the police officer as more credible or not. There's better ways to ask those questions. So how effective is jury selection? Well, when done in a bunch of different trials, right, demographic characteristics of jurors are weakly and very inconsistently related to verdict, and it is genuinely dependent on case type. Overwhelmingly, the only real examples where demographics might matter is that in sexual harassment, it's typically better to have a majority female jury than a majority male jury. In ADA violations, the same is true, right? In white-collar crime cases, it's typically better to have wealthier people than not wealthy people. But again, very small effect sizes and very inconsistent research, right? Personality characteristics of jurors are only modestly, they only modestly affect these jury decisions, right? So like belief in a just world, or you believe that people get what they deserve, versus an authoritarianism, or you know, it's your job to, you know, control your destiny, right? Those are modestly effective of juries, but again, small effect sizes. The best prediction of verdicts are specific attitudes that are relevant to that specific case, right? So for example, if I were to ask somebody, in general, do you drive a foreign car? Or do you like foreign cars? That's not going to be a very good question, right? It's far too broad. Am I talking about a Mercedes? Am I talking about a BMW? Am I talking about a Yugo? Like, what am I talking about? What's a foreign car? Whereas if I, again, in the hypothetical example of me representing Honda, if I'm representing Honda and I say, do you have a Honda? What is your opinion of a Honda? Talk to me about Hondas. Those attitudes are going to be more relevant, because if someone's suing saying their Honda was built inefficiently, and I've got a bunch of people on the jury that say that Hondas are some of the most reliable cars in the world, then I'm going to have a really a good chance of winning my case, because the other side is going to have to overcome these attitudes that people have about Hondas. So, if we were to actually look at attorneys specifically, right? If we take a jury sample, what we see here, again, is with the exact same attitudinal component, the same jury sample, if we were to look at a jury of 12 individuals chosen by attorneys and compare that to a jury of 12 chosen at random, and then compare that to literally the first 12 people to walk into the room, we see actually no difference. They all have this same attitudinal composition, right? And so if attorneys were actually good at jury selection, you would think there would be different attitudinal compositions between the two, but we don't actually see that. And that's a big problem, right? Because attorneys think they're doing this great thing for their client, but they're not. Now, do attorneys always follow the rules? Well, you should know automatically straight out of the gate that probably not, right? Attorneys are not supposed to select jurors based on a cognizable group membership, right? And that's why we have these Batson challenges. Defense attorneys initiate the challenge by establishing a case of prima facie racial discrimination. And the prosecuting attorney needs to justify the challenge. Of course, the assumption with this procedure is that there is no other reason but race, and that we can identify some other issue. But regardless, only about 18% of Batson challenges are actually successful, and of that 18, only 2% of those actually did the attorney admit that they were actually racially discriminating. And so the vast majority of time, Batson challenges are not successful, even when attorneys are very clearly eliminating a cognizable group from the jury pool. Now, this has led to kind of this scientific jury selection, all right? This idea of scientific jury selection. And it really started with the Harrisburg 7, right? And it was a trial of Philip Berrigan and 6 other anti-war activists, anti-war, specifically the anti-Vietnam War. And Schulman and colleagues, Schulman's a sociologist, they were sympathetic to the anti-war movement. And so they successfully demonstrated the need for a new veneer after they did 1,000 telephone surveys comparing demographic data for panels within the jurisdiction. And they constructed a kind of ideal juror profile. They wanted a female Democrat, white-collar or skilled blue-collar worker with no religious preference. The jury was 9 female and 3 male, and the trial ended in a mistrial. And so people said, wait a minute, maybe there is something to this scientific jury selection, right? Now, again, we've already talked about how demographics are not very good predictors, but maybe there are other things, and that's what's led to increased study of jury decision-making. So in the 1980s, there was this big expansion where the marketing surveys and consumer profiles were used. There were very controversial research methods, but psychologists, sociologists, and attorneys were all in on this endeavor. Scientific jury selection is very, very customary in serious civil suits, and in fact, I think I have only worked, I'm having to think right now, I think I've only worked, of all the cases I've worked, I think I've only worked one criminal case, and the rest of them have been civil, and I've worked 15 or so jury selections in my short time since graduate school started. Obviously, they're very, very common in high-profile cases. O.J. Simpson had a jury consultant or litigation consultant. Martha Stewart did. Dr. Phil actually got his start as a jury consultant working for Oprah. There's no licensure at all required for trial consultants. Anyone can do it. You guys could tomorrow, if someone was willing to pay you money to do it, be a jury consultant. And services include a lot of different things, not only scientific jury selection, but theme and argument development, witness preparation, technology preparation. The main thing that I've usually helped with is mock trials, where we actually get a group of the population where the trial is going to be held to actually come to a hotel or some sort of convention center, and we actually try the case in front of fake juries. And then watch those juries deliberate, watch them talk to each other, and watch how they decide who's guilty and not guilty. And then that helps inform our trial strategy. Now, one of the things that is super important in scientific jury selection is that it rests on the assumption that a person's individual differences and attitudes will predict how he or she will decide a particular case. But what's super important is that attitudes only matter in cases in which the evidence is somewhat ambiguous. All right, so it's limited by the type of case or evidence there, right? So if you look at this chart here on the right-hand side of your screen, from about 75% up, where there's strong evidence, all the jurors are going to convict. It doesn't matter who you have. If the evidence is just so powerful against the defendant, they're going to convict, right? Or rule in favor of the plaintiff. From 25% down, all the juries acquit. Right, or side with the defense, right? There's just not enough evidence. It's only this area in the middle where attitudinal and individual differences may be actually predictive of verdict. And that's super important, right? Because what a lot of attorneys do is they say, oh, north of I-10 or south of I-10 is my cutoff. But if there's strong evidence in the case, they think I picked a great jury, but it really wouldn't matter what jury they actually picked, right? It only matters in cases in the middle. Now, community surveys are the most common mechanism for scientific jury selection, and this is just a survey of the community population from which the jury panel will be drawn. They'll be given a synopsis of the case, and they'll be given questions designed to assess case-specific attitudes toward the legal system, the defendant culpability, and get basic demographic information. And then statistics are run to examine the relationship between attitudinal culpability and demographic measures. So, are males more likely than females to think this within this community? Are white people more likely than black people to have this opinion, right? Another method is a jury questionnaire. These are questionnaires prepared by both sides and agreed to by the judge that's given to the veneer prior to the actual jury selection. And it's intended to provide information in an expeditious and cost-effective manner, right? They'll include probably the very similar questions to the community survey, but they may also assist with in-person questioning. So you might say something like, hey, juror number 3, I noticed on this questionnaire you wrote this. What did you mean? And you can have them elaborate on whatever the case may be, right? And then there's also observation of potential jurors. And this is nonverbal communication cues, reactions to questions, how they react and interact with other prospective jurors. That will make you decide what you want or don't want in your jury. Some theme development methods are mock juries, right? You present these mock juries with evidence, you record the deliberations, and then this is actually one of my favorite parts, is you ask about alternative scenarios. What if this was presented? What if we had said that? What if you found out this now? Does that change your opinion at all? What does the other side need to do to convince you that they're right? And then see what they have to say. And so you can analyze the narratives that mock jurors create to kind of create this cohesive story, and we'll talk about that in the next lecture. To create this cohesive story, for your actual trial. Using this story to develop a theme that you can reinforce in voir dire, evidence presentation, and opening and closing statements is extremely powerful, right? So if, for example, if we're representing Honda and we want the theme to be throughout the whole trial, Honda is a reliable car, you need to hit them with that as soon as possible in voir dire and get the jurors to even admit to you, yes, I think Honda's reliable. And if they do that, then you kind of keep reinforcing that throughout the trial, and then by the end of it, they're going to say, I came here thinking Honda was a reliable car, and I left here thinking Honda was a reliable car. Another idea that litigation consultants use are shadow juries. And this is after the trial jury is chosen, a shadow jury is assembled that mimics as closely as possible the exact demographic makeup and attitudinal makeup of the jury seated. These are very, very expensive, but the shadow jury will provide input to attorneys and consultants throughout the course of the trial. So every time the jury is excused, the shadow jury leaves. Every time the jury comes back in, the shadow jury comes back in, and you say at the end of every day, what do you guys think? How's the plaintiff doing? Good or bad? Bad? Why are they doing bad? What could the plaintiff do to be better? Okay, how's the defense doing? Good or bad? And then you can get that information from these people that are watching it that should, in theory, be thinking in very similar ways to the actual jury to help modify stuff. You might leave after examining a witness, and the shadow jury might say, I didn't understand a lick of what was said. That made no sense to me. Like, they need to clarify a lot of things. It's better to know that when you can still do something about it, as opposed to at the end of the trial and you get a verdict you don't like. Again, super controversial though, because they're very, very, shadow juries especially are very, very expensive, and there's something that makes people kind of uncomfortable about the idea of shadow juries. Does scientific jury selection actually work? Well, work compared to what? Compared to random? Compared to attorneys? Better at what, right? Better at weeding out bias, or better at stacking the jury to your side? Well, variability in voir dire practices leads to practical limitations on scientific jury selection, obviously, right? There's not been a great study examining the efficacy of scientific jury selection compared to traditional methods, right? Examining statistical relationships among variables, linking outcome with selection, and comparing to traditional methods. It doesn't really work all that well. But there are some kind of case studies that we can look at. One in particular is the case of O.J. Simpson. Now, this is his murder case, not what he just got paroled on. But both sides used trial consultants. One side listened to their consultant and one didn't. Guess which one didn't, by the way? Marcia Clark was told by her trial consultant to try and exclude people of African American descent in general, which technically is illegal, but to come up with reasons to do it, and especially female African American jurors. This was based on a survey the consultant conducted where he found that African American women often have opinions like in every relationship there's a little trouble and domestic abuse doesn't mean he killed her, right? And so the prosecutor was told, Marcia Clark, the prosecutor was told, get rid of all the black people you can, specifically black females. Well, Clark thought her consultant was full of it and believed that any woman would be sympathetic to the prosecution given the domestic abuse and didn't want to exclude any women at all. She actually wanted as many women as possible on the jury. What's ironic is that attitudes about domestic violence were not predictive of verdict in this trial. In post-trial questionnaires, though, it showed that black women on the jury tended to view Marcia as a castrating bitch who was attempting to demean the symbol of black masculinity, right? And so the black women viewed Marcia Clark, a white woman, as actually being kind of racist against a black man. And not only a black man who was a Heisman Trophy winner and a professional athlete and someone a lot of black females actually kind of had a crush on and looked up to as the symbol of black masculinity in the African American community. What's ironic is, was the O.J. Simpson jury representative? Well, remember, the defense also had a jury consultant who said, we want as many black people and women on this jury as possible. The prosecution wanted, in theory, the consultant wanted no black people and specifically black women. They were essentially trying to pick the same jury, and if you look here at these descriptions of the jury, they pretty much did, right? All 12 jurors were Democrats. Only 2 graduated college. Not a single juror read a newspaper on a regular basis. 2 had supervisory or management experience at work, 10 didn't. 8 watched evening television tabloid news, which tended to predict a belief in OJ's innocence, right? So 8 people had this pretrial publicity, which we talked about last lecture, that said OJ was probably innocent. 5 said that they or a family member had personally had a negative experience with the law. 5 thought that using physical force on a family member was sometimes justified. And 9 of the jurors thought O.J. was unlikely to have committed murder simply because he excelled at football. So, again, the consultant gave advice that the attorney didn't listen to. Now, this is not to say that consultants are always smarter or better than attorneys. That's not necessarily true. But in this case, we saw that scientific jury selection clearly played out in O.J.'s favor. Now, the ethics of trial consulting are present, obviously, and you guys probably have thought about some of this stuff already as I've been explaining it to you, right? First of all, there's a wealth issue. Jury consultants are very, very, very expensive, right? You cost anywhere from $5,000 to $100,000 depending on what is getting done, right? And so this automatically puts people from lower socioeconomic statuses at a disadvantage. Now, I personally do a lot of pro bono work, but I don't exclusively do pro bono work. I obviously have to pay my bills as well, and so I work for corporations like I've talked about in this lecture. But regardless, it does put people from a lower socioeconomic status at a disadvantage. Already there's a wealth discrepancy in our system. Is trial consulting just exacerbating that discrepancy more? Some would argue, sure, right? Also, there's a potential constitutional issue. Are the juries really fair if one side has scientifically predicted what will introduce bias into the process? Is it fair for someone to hire me to say, bias the jury in my favor? Is that actually constitutional or not? Some people argue it's not, right? When opponents are not equally matched, obviously the superior one will more often win, right? And so there's been some suggested reforms here, right? Maybe we should ban trial consulting. Or maybe restrict questioning of voir dire. Maybe always make it all judge-appointed voir dire. Maybe eliminate preemptory challenges, and that's actually a big one going around right now. There's a lot of research going on right now as to whether or not we should ban preemptory challenges. Requiring jury consultants to share information with both sides. If I get hired by the defendant, should I have to turn over my report to the prosecution as discoverable information or not? Or maybe regulating consultants through licensure and professional standards. The thing is, as long as litigants are expected to present their version of the case as zealously as possible, a lot of these reforms can't be accepted, right? We hire attorneys in an adversarial system to duke it out as best as possible, right? To have this big fight, this epic battle in trial. Well, if you have backup in the form of a consultant, isn't that as zealously as possible defending your side? Kind of, right? And so it causes a lot of problems here, and there is no easy ethical answer to this. Now, granted, for me there is. I think it's totally ethical, otherwise I wouldn't be doing it. But with that being said, I understand a lot of people who say that they have some ethical issues with it. Anyway, that's all we're going to talk about today, and I will see you all next time.